applications in the matter of Jalla and another, and Shell International Trading and Shipping Company Limited and another.
My Lord.
Yes, Mr.
I appear in this matter together with Mr. Cribb and Mr. Chan for the intended appellants, and my learned friends Lord Goldsmith and Dr. Blake and Mr. Cornell appear for the intended respondents, the two named Shell companies. My Lords, if I could direct your attention to the judgment of Mrs. Justice O'Farrell, which I shall be referring to a number of times, and so for convenience, I have removed it from where it is found in the bundle, which is Core Bundle Volume 1, Tab 9. And I've kept it as a separate document for easy reference. I wanted to start by way of explanation. Lord Justice Coulson will already know this because he's already entertained 2 appeals in these proceedings. But just looking at paragraph 1, in a word of explanation, the 2 proceedings that are referred to in paragraph 1 of the judgment. The first one, HT 2017-383, that is the proceeding that we've referred to in our skeleton argument as Jalla 1. That was the claim that was commenced in December 2017, and it was intended to be brought, although that was not a success, by Mr. Jalla and Mr. Chuja, 2 named claimants, as a representative action on behalf of some 27,000 individuals and 450 or so communities, who were subsequently listed in schedules to the particulars of claim. Now, I just should also point out that that commencement of the action in that form and the early stages of the claim were handled by a different counsel team than that which is comprised of myself and my juniors. Now, just yesterday, the Court of Appeal handed down publicly its judgment upholding Mr. Justice Stuart Smith's decision, which he made in August 2020, that action, Jalla 1, the 2017 action, could not proceed as a representative action, was not and could not be a representative action, to use accurately the words of Lord Justice Coulson, who gave the judgment of the court. And so that action is now proceeding solely as a claim by Mr. Jalla and Mr. Chuja in their own personal capacity. Now, the second action that's referred to in the first sentence of the judgment is what we've referred to in our skeleton argument as Jalla number 2. That is HT 2020-143. That was commenced in April 2020 by a virtually identical cohort of claimants as those who were intended to be represented by Mr. Jalla and Chuja in the would-be representative action. And that arose in this way. For the first 2 years or so, the proceeding, which was then entirely comprised of the would-be representative action, the 2017 action, was the subject of an intense jurisdictional dispute. And that was the matter that was determined by Mr. Justice Stuart Smith following a hearing in October 2019.
Yeah, I mean, Mr. Dunning, we've done our homework, so we know the procedural history. That there may well be points you want to make on the procedural histories. I'm not stopping you.
No.
If you're just laying out the history, you probably don't need to, but you may be wanting to do more than that.
I thought you might say that, and I was just conscious that I have one judge who's heard appeals in this matter twice, and 2 judges who are new to it. But you've done your reading, and I will take the procedural history lightly. But what I just wanted to emphasise is that at the end of that jurisdictional battle, a judgment was produced dated the 2nd of March 2020. And following that, the point was taken that the proceedings couldn't thereafter proceed as a representative action. And that then led to the issue of the 2010 proceedings in April 2020. The question of whether the proceedings could proceed as a representative action in the first proceeding was then decided by Mr. Justice Stuart Smith following a hearing in May 2020 in his judgment handed down in August 2020. And it was the appeal from that which was determined yesterday. The only other thing I wanted to stress, I think, from the procedural history is that in his judgment on the jurisdictional battle, Mr. Justice Stuart Smith held that the claims were sufficiently arguable to pass the test for service out of the jurisdiction, for example. So probably, I don't want to get into a debate as to what that test is, but let's say it's serious issue to be tried or something approaching a good arguable case. But he held that there was an issue of limitation which he couldn't determine as an interlocutory matter. And as a result, he set up what has become known as the date of damage trial, because apart from anything else, that would go to jurisdiction. Because if and insofar as the claims were time barred, as against the anchor defendant, that's say one of the two shell defendants, which is an English company and served as a right here, insofar as the claim can't proceed because of time bar against the anchor defendant, then there would be no anchor on which to secure the proceedings against the Nigerian shell company. And so that was left over, as it were, from the jurisdictional aspect of the proceedings, and he made directions at a hearing in late March 2020 in what was then only the representative proceedings, for the date of damage to be determined at a trial following a service of a pleading in relation to date of damage and witness statements and experts' reports. And that is that is what the learned judge then refers to in paragraph 5 of her judgment. And if you could go to paragraph 5, I'll give you the references in due course, actually, for those matters.
Speaking for myself, obviously, I've looked at the direction.
You've looked at the orders. I mean, if you can't locate them because there are a number of bundles, I'll certainly give you the references.
Well, I've marked them all up.
So now the other thing, of course, that I wanted to draw your attention to in paragraph 1 is that in the second sentence of paragraph 1, the judge explains the application that was before her, and in respect of which we appeal against her decision. And we accept that that was a case management decision. So we accept that this is an attempt to appeal against a case management decision. We accept that on the authorities, the Court of Appeal is certainly reluctant, and one can put it in various different ways, but let's say reluctant to allow appeals or even give permission to appeal in relation to case management decisions. But on the other hand, a case management decision is not immune from appeal, and appeals are possible in cases which we submit this case is, of one where the learned judge made significant errors and omissions in relation to the factors that she took into account in the exercise of her discretion. And as a result, in our respectful submission, she reached a decision which was outside the generous ambit of possible discretionary decisions which were available to her, and which was not properly explained in her reasons. And if I could then summarise, before I go any further, the essential points on which we seek permission to appeal and wish to appeal. And there are 4 points.
These are just the grounds.
And these are the grounds, and I just explain it as briefly as I can. The first point is that Mrs. Justice O'Farrell failed to grasp fully what was the extent of the application before her, and what was therefore fundamentally at stake on the extension application, depending on whether she allowed or refused it. which was this. If it was refused, then only 4 individuals and 5 communities would be able to contest limitation at the date of damage trial in February 2022, and all of the rest of the 27,000 or so individual claimants and 450 or so communities would not be able to contest limitation at that trial, and therefore that was effectively the end of their ability to pursue their claims in this litigation, subject only to one point in which we are still in a state of uncertainty, and that is that following the decision of Lord
Well,
Justice...
can we not take this more shortly? Do you mean subject to the continuing nuisance point?
Exactly.
Yeah.
Yes.
Okay.
I'm sorry, my lords. I'm
No,
obviously
you never
over-catering
know.
for the
I
fact
never
that
knew
2
when
of your
judges said they'd
were
read the
not in
papers whether they
previous
really
cases.
had, but
Yes.
so that's fine. But I hope I'm demonstrating on that respect at least. I do not.
Absolutely. So unfortunately, on that, I can't update you. We applied for permission to appeal in time in February. It was acknowledged, I think, on the 2nd or 3rd of March by the Supreme Court, and we've heard nothing since.
But it doesn't really matter, does it? Because the judge was bound to proceed on the basis of the decision of this court, which by then happened, that there was no continuing nuisance, or that they couldn't base a claim on continuing nuisance.
And that's all I was going to say about it,
Yep.
because it is lurking there in the background.
No, we have that.
As
Yep.
things stand, it doesn't matter, and therefore the effect of what looks like an extension for something which doesn't immediately strike one as having such radical and draconian consequences actually has very radical and draconian
I don't know,
consequences.
that doesn't immediately strike one. I mean, anyone knowing the history of the litigation would see it as crucial.
Well, I'll take you through the judgment in a
Yes,
minute,
okay,
but,
you're just trailing, so I'm going to resist arguing the point with you, or
and-
try to resist.
So that's
point 1.
That's point 1. Now, point 2 is that what happened is that the learned judge asked a question to me at one point as to, as at the 2nd of July, how many dates of damage could be provided if at that point in time. And obviously we were seeking an extension until the 20th of August, so I didn't know how many could be done by the 20th of August. But as at the 2nd of July, she asked me how many would...
20th of July.
Sorry. Yes,
Because
so we were as at the...
because as at the 2nd of July...
At the hearing.
Yeah, I was going to say, as at the 2nd of July, you had what you had.
Absolutely right.
But
Sorry.
by the time of the hearing, 20th of July,
Yes, and she
that was
said,
the judge's
how many could you do? And my instruction, I got instructions, WhatsApp or whatever it was, during the course of the hearing, that we would be in a position to do 900. And what's the plan?
So when you say do,
to give dates. Well, so this is what I want to explain. It's all we wanted to do, and we're asking to do, and I want to come back to this again for the present proposed appeal, was that you may have seen it, or may not have seen, but in the bundles in bundles 2, 3, and 4, there are very long schedules which list the claimants and the communities. And effectively, what we were proposing to do was to add an additional column on the right of those schedules that contained the date of damage for each.
well, that's what you were required to do by...
Exactly. So there was talk about schedules and so on. It was as at that. So the answer to her question, certainly what I intended to convey, is that as at that time, when she asked that question on the 20th, or Justice Coulson is right, 20th of July, we were in a position very promptly to give the particulars of the date of damage for 900, but obviously it was hoped that more could be done by the 20th of August. And what happened, and this is...
Can I just be clear?
Yeah.
The moment you're just trailing these points, you're not developing them.
No.
So, right, well then I will keep my questions till you do.
Okay. So the second point is that when I gave that answer about the 900, Mrs. Justice O'Farrell appears to have considered that that was the application I was making. But what she didn't do in any event was to consider whether there would be any harm in serving at least those 900 which were available at that point in time, which would have been a less drastic course of action because those could have been served within a day or so, certainly no more than 7 days. And that is really what we are putting forward as our ground number 2.
Can I just ask two
Yes.
questions for short answers, and you can come back, but just I see where this is going. Did you make an application to that effect?
I did not make an application expressly to that effect because I didn't have instructions to do so. There was some debate about...
Okay, so no, I'm sorry, I will let you develop it. So the answer is you didn't make an application, but you'll explain why later. Secondly, you didn't say, indeed I think you made it clear the contrary, that there would be 900 witness statements supporting those.
No, I certainly made clear the contrary.
Yes,
so,
right.
Although the application had referred to evidence, by the time of the hearing, my express instructions, which were recorded in the skeleton argument, and why I took the then judge to the skeleton argument, were that I was not seeking permission to serve any further witness statements in support of those schedules.
Well, that's what I understood.
And she correctly recorded that in paragraph 15 of her judgment.
Okay, thank you. Well, we can come back to the implications of that later, but since you're trailing the submissions rather than making them, I won't debate it with you now.
Now, what I think I should do is to update the court as to the current position. So I don't know whether the court received a copy of a letter that we wrote earlier in the week.
Yes, we did.
Which has gone into the bundles at supplemental bundle tab 46.
I'm not sure it's actually physically gone in the bundle, but I know the one you mean.
But I'm sure we can provide copies if it's gone missing in any way. But what we indicated in there is that work had continued on the schedules, the dates of damage, but that we had not served them as we had indicated we would do in our application to this court, because there was very strong opposition to that by Deverwas, and we attached Debevoise, I'm sorry, and there was very strong opposition from Debevoise in a letter which we attached to that letter, and those letters are both in tab 46 of the supplemental bundle. If they're not, we can provide copies. So what has happened is, in the meantime, work has continued, and I am therefore now in a position to tell the court what the current position is as of today. And it has not been possible for 100%.
You can, though it's hard to say why it would be material.
Well, because if the
question is whether the judge was right at the time on the information before her.
I entirely agree, but if she was wrong, it is material then as to what order the court would make.
Well, let's hear what you have to say. Yeah.
I mean, it's just numbers, my lord. It's just so that you have an appreciation of what's at stake. So the work has continued, and my instructions as of this morning is that data damage can be provided for 165 communities and 22,167 individuals.
How many communities?
165. Yeah.
And how many individuals?
And those numbers...
Sorry, how many individuals?
22,167. 22,167.
Can I just ask one question that's puzzled me reading through this? Does every individual belong to a community? Or are there some freestanding or floating individuals who are not members of any of the communities in question?
Can I just take instructions on that? Because I think I know the answer, but I don't want to give you the wrong answer. I'm told that they are all in the listed communities.
Yeah.
So,
Well, in that case, it's a bit pointless. I mean, I don't mind you doing it, but there's no real distinction between the number of communities and the number of individuals for the limitation point of view, because presumably the oil arrived in a community on a single date. It's hardly likely to have arrived for different individuals in that community on different days.
well,
Or is that wrong?
well,
I'm assuming a community is a geographical
in
entity.
layman's terms, that's right. But in legal terms, there is a difference because the communities don't have legal personality as such. And
Oh, I understand that point,
yeah.
of course. And the whole division between communities and individuals is a pragmatic one rather than a legal one.
Yes.
But in fact, the very limited evidence that has been provided has effectively been, although it's been by named individuals, it is it's saying when the oil arrived in this particular village.
Well,
that
I
must
haven't
be the
checked the
case.
schedules, my lord, myself, to see whether the dates are all very much lined up. And again, I could take instructions on that.
I just want to
Doesn't
understand
mind
it as
being
background. I
correct.
can't believe it's going to be essential.
My lord, the other thing I should update you on is when we wrote that letter, we attached to it the revised draft of the order that we would seek if the permission was given and if the appeal succeeded. And it was to serve the dates in the schedule by Friday. And it also said any amended pleading to incorporate that and supplemental expert evidence. Now, we're no longer seeking any supplemental expert evidence. So the position before the learned judge was we were not seeking to serve any witness statements in support of the schedule. Now I can confirm that we're not seeking to serve any expert evidence either in support of the schedule, other than the existing evidence, which I'm going to take you to in a moment, which has already been served.
So
And
it's
was
just
served in time.
reformatted schedules.
Well, yes, reformatted. If that means
Reformatted with the dates on the right-hand side of the column
with a
for
column.
165 communities and 22,167 individuals.
And I believe that during the course of doing that, other errors have been spotted. For example, I was told there were over 100 duplicate entries. So they're deduplicating, for example, if they find an error in relation to something like that. But essentially...
But just to avoid the unhappy position where it's never quite clear what's being sought, what is being sought is reformatted schedules only, with dates for these individuals.
Yes,
That's what you'll serve on Friday, which rather assumes you'll get an answer today.
Well, we said Friday or within 24 hours of the Court of Appeal's decision. So we did cater for the possibility. We didn't assume that we were getting
But that's the proposal.
That's the proposal. And all I would say is that although I'm not seeking permission for it, that the schedules will include obvious errors that have come to light in terms of tidying it up. But I don't need to seek permission for that now. But if that proves to be controversial, which I very much doubt, then we can deal with that at the case management conference in a couple of weeks' time. So, my lord, you said two questions. I think
No, you answered both of them. The first was whether you made an application, effectively, will at least give us 900, and secondly, whether what you were promising was only pleadings rather than witness statements.
Yes. And if I could
You've
just
answered both points.
just a word of explanation. I'm instructed by the entire group, and obviously it would to make an application on that occasion without instructions to do so on behalf of only a small subset of the group would have required express instructions, because there's effectively a conflict between the interests of the clients. It could be perceived as being a conflict between the interests of the clients. Now, the third ground and the third point is we respectfully submit that Mrs. Justice O'Farrell overlooked and failed to evaluate critical arguments that I advanced for very specific reasons in this case, why the material that we were seeking to add that if the extension was granted, namely the dates essentially, would not cause any appreciable prejudice to these defendants and no real prospect of jeopardy to the trial date. Now, and you all have seen, and I'll come back to it in a minute, that in a couple of respects, the Lady Justice referred to the interests of other court users and disruption to trial dates and so on. Now, the premise of that was that there was real jeopardy to the trial date, and those considerations which he put in the balance were premised on there being real jeopardy to the trial date, but it was a major plank of my submissions that there was no jeopardy to the trial date, and that essentially, this is a case in which Shell protest too much, because the reality is, when one looks at the very large amount of evidence that they have already served, and the way that they have indicated that they intend to conduct their case, that these dates are not going to make any appreciable difference to them. Therefore, there was no material prejudice that they couldn't cope with and still can't cope with if these schedules are served later this week or early next week, in time and allowing the trial to go forward as planned. We still say that that one has to actually consider what is the evidence that's been served, how have they indicated that they intend to contest the case, what work have they been done, what circumstances are they in, and I will come to all of these things very briefly when I develop the ground. And then the fourth ground, which is linked very closely to the third one, is failing to give reasons for rejecting those arguments on the normal Flannery and English and Emery type basis, and I'm sure you're familiar with those cases, and I won't say more about that right now, at least. Now,
so that's the menu.
yes.
How long are you expecting to be developing those 4 points?
Well, what I can do is I was going to take you through some of the procedural history of the order, but it sounds as though that is not necessary, and therefore I will turn to developing those points, and I would have thought I would do that in about 45 minutes.
Well, yes, I mean, realistically, you're not going to make separate, we're not going to, as it were, adjourn to decide whether to grant you permission, and if we grant you permission, give you a second bite of the cherry. So I think you need to make all your submissions in one go,
yes,
on the basis that you may get permission.
Yeah. Well, that was
that's how it's always done. That comes as a surprise to you, but I just... well, that's fine. You take. I just wanted to be clear that if we decide we wish to hear from Lord Goldsmith, that there's going to be you're going to leave enough time for that. If your prediction is correct, you're going to leave ample time for that.
I mean, maybe I will.
On we go. I just wanted to.
I certainly would
check.
finish, but to leave him the bulk of the afternoon. Obviously, I may want to.
Well, it's 45 minutes. It won't be just the bulk of the afternoon. Keep going, Mr. Dunning. I just wanted to get a general picture.
But so I won't give you the references now, although I can, to the previous directions, and I will skip over that part of the procedural history. Now, what I should highlight for you is why this application became necessary. And that was the second subject matter of our letter to the court earlier in this week, where we enclosed a summary of the evidence. In relation to that, which was placed before the court on the 20th of July. That is also was attached to that letter and has gone into the supplemental bundle. And that is at supplemental bundle, page 410. So, my lord, have you had a chance to read that summary already?
Well, I haven't read the summary, but I've read the evidence.
You've read the evidence. Well, that's even better. But there's the summary, and what I've done there is combined.
Well, sorry, I should be more accurate. I have read the evidence, but I've not read all the exhibits. I didn't.
No, I'm not. What I'm talking.
Well, for example, you see, you're talking about. I've read Ms. MacLeod's statement, and Mr. Roche's. I haven't been, for example, to the cross references to the transcript.
No, that's fine. That's fine. So so long as the court has the body of material that we presented to the court as the explanation for the necessity to make the application, and that's the summary of it that I hope is accurately and fairly summarised, and that sets out the very considerable efforts that have been made to get boots on the ground and to investigate matters.
Well, does it? What puzzled me was that I didn't understand the relevance of Mr. Roche's expedition to the particular exercise we're concerned with here. The exercise we're concerned with here is to get a date of first arrival of the oil at each community, which will therefore cover all the individuals living in that community. Well, so that's 470.
Yeah.
And we see how that was done in the 5 cases where it has been done. Someone authoritative in that community says, on such and such a date, I saw the oil washing up in the mangroves.
Yeah. Well,
let me just finish.
Yeah, sorry.
It was never intended, clearly, that Mr. Roche would visit all 479 communities, interview someone, take a statement, get them to sign it, and get back on the boat. He says that he weren't able to visit as many communities as they intended, but it's quite clear from his statement that they were only going to visit, even if everything had been more straightforward than it turned out to be, a handful of communities. So I'm not quite sure why all that very understandable evidence about how difficult it is to get about in those communities really bears on the problem of getting a date and a witness statement.
Well, my lord,
I mean, the witness statements you did get aren't ones that were obtained by Mr. Roche.
Well, I don't know.
Look, they don't seem to be for the communities that he visited.
But my lord, he does say that the intention was to visit each community.
Where are we?
Well, if you're on my summary.
Well, I'd rather look at the evidence.
I know, but I just pointed where it is in the summary, and then so it's on the summary on the third page. On the third page. And the second bullet point, and the evidence is paragraphs 31 to 39, which are in supplemental bundle tab 28 at pages 168 and 169.
He says as many communities as possible. That's my understanding.
Well, let me just see where I got. No, 35.
Yeah, each being the ones he's identified previously. He says at paragraph 32, we had to devise an itinerary that enabled it to visit as many communities as possible within the short time frame. There's no reference to how many he intended to visit. He identifies the ones that he did then visit.
I see.
I think that was my lord's.
I see.
That was the impression it made on my lord. It was the impression it made on me.
That's a fair point. I agree with that. Yeah.
Well, it's a fundamental point, isn't it?
Yes. Well, I misread 35.
Sorry?
I had misread them. I apologise for that, because when it said each community, I had understood that.
All right, if you say so. But surely what was required following Mr. Justice Stuart Smith's direction was to get in touch with an appropriate person in each community, so shy of 500 people, identify who such a person would be, ask them this question, and get a signed witness statement from them.
Yeah.
And there is no evidence that I have seen about how you set about doing that.
Well,
certainly Mr. Roach's evidence doesn't deal with that. I don't think Mr. MacLeod's does either. But again, you take us to it if you will.
Well, they deal with they deal with the difficulties of doing that, in the sense that they say that there aren't means of communication, and I think there are also.
Well, they say they're very different.
Language.
So they don't. Well, they don't say. If they say about language difficulties, I didn't get it. But I mean, the fact is, you're managing this very tricky litigation, and if there are several of the communities speak different languages, you just have to have an interpreter for each. There must be, I hope there is, some quite sophisticated administrative structure in Nigeria working out how to deal with each of these communities.
Well,
I say quite sophisticated, I don't mean enormous, but enough to ring them up and ask these sorts of questions. And it's explained that internet communication is intermittent, you have to phone people, and then they know that they are required to go to their computer. All that I do understand, and I'm not quite understand the Nigerian Delta is not like Southeast England, but we're dealing with a period of over a year in litigation where you've got to have some system of dealing with your clients. And what I would have expected to see in the evidence was some explanation of how it proved this was our plan. We were going to deal with, 20 a week or 30 a month or whatever it was, and we would be able to deal with them all in this time. And we had a team doing it, but we was unable to do so because the phones didn't work. Now, there's nothing like that, except a few generalities.
Well, I agree. We haven't gone into all of that that extensive detail. But my lord, unless there's some suggestion of bad faith on behalf of the claimants, I mean, the claimants have been doing their level best. But we got to a point.
It's a question of bad faith, Mr. Dunning. The claimants on the 20th of July were throwing themselves on the mercy of the court.
Yes.
And when you do that, it's traditional that you explain how you've got to that position.
Yeah.
Now, the statements of Miss MacLeod and Mr. Roach, which deal in generic terms with the difficulties, contain, I think, one date each. One refers to a date in March 2021, one refers to a date in May 2021. Mr. Justice Stuart Smith's order was March 2020, and there is no explanation that I'm aware of for any of the delays effectively for a year between March 2020 and March 2021. And that is, I think, the point that at the moment I'm stubbing my tongue. I get all of the generic difficulties to which they refer, but it isn't a question of bad faith. It's a question of, can the delays be explained?
Yeah.
And usually you do that by reference to a chronology.
Yeah. Well, I see the force of those points, but it's not, in fact, a point that the learned judge took into account against us.
Well,
as I
that's
see.
a fair point, and we may have to come back to that at the moment. I can come back to that later.
Yeah.
But
But my lord, I think the main point that we certainly make in terms of prejudice, and we'll come to the other point as well at the moment, is that the learned judge accepted Lord Goldsmith's submissions about prejudice.
I'm sorry, just so I'm trying to keep a systematic note.
Yeah.
this was the heading, why the application became necessary,
yeah,
and you were
I-
going to explain that to us.
I-
That you took it, you reminded us of the evidence. We have put our difficulties. Is there any more you want to say about that?
No, I don't think I do, unless I get some further instructions. What I wanted to do next, so I won't jump forward to the prejudice point. What I wanted to do next is just to be very clear about what the extent to which we did comply with the order on the 2nd of July. And because in my respectful submission, the judge hasn't fully taken account of what was in fact served and the full extent of the claimant's case, which was thereby notified to the defendants. And when I make these submissions, I would ask the court to also bear in mind the background here, which is as follows. Shell started dealing with and investigating this spill in 2011. They knew about it at the time, and they mobilised their emergency response team based in England. And their case is that it was cleaned up at sea by their emergency response team and never reached the shoreline. But nevertheless, they set up a scheme to monitor the environmental impact for, I think it was 2 or 3 years, and we have a document that showed that. That's the first bit of the background. The second bit of the background is this is not the only proceeding relating to the Bonga spill. And indeed, this was why there was a contest about jurisdiction, because Shell's case was that there were lots of other proceedings related to the Bonga spill, and you can see them all set out in Mr. Justice Stuart Smith's decision, including a federal action brought by the Attorney General of Nigeria, but many other actions as well, and all of which they claim they were contesting in Nigeria, and therefore their case was that these proceedings shouldn't be heard in England at all because of Article 34 of the Judgments Regulation. But the point for present purposes is they're already dealing with all these proceedings in relation to the Bonga spill and its impact on communities all over Nigeria. And the third point in terms of the background is that Shell are a very large and sophisticated organisation with very long established roots in Nigeria, where they have been for decades, and they have been dealing, as we all know, with environmental issues for certainly several decades, and have a team. One can infer that they have a team and an experience to deal with those matters. Now, I will come to, in a moment, to what they have in fact served in these proceedings, because they have served a lot of very detailed evidence, which is why I say that they protest too much. But against that background, what did we serve and what did we notify them of? Well, we served, first of all, our date of damage pleading, which is the document which is to be found in Core Bundle Volume 5 at tab 16. And that, so that bundle is made up entirely of the...
It's my volume 4, Mr. Dunning.
Oh, well,
but it's tab 16, but I'm...
It's tab 16 then. I don't know why your bundles are slightly different from mine. But it's page 1048 of the core bundle. And that is the date of damage pleading for about 40 pages or so, followed by some contemporaneous documents that are attached to it. And if you look at paragraph 6, there is an overview of what is contained in the date of damage pleading, set out in paragraph 6.1 to 6.6. It is won't take too long over it, but it's a substantial and detailed document.
But most of it's not really directed to the point, is it?
Well, it's detailed.
The point is, when did the oil wash up in each of these communities? A lot of it's pleading evidence, facts, and by reference to evidence, about how oil behaves and so forth.
Yes. No, I accept that. It deals with the migration and why. I mean, and this is against the background that Shell's case is, none of it reached the Atlantic shoreline, let alone proceeded inland along the waterways. And so what the real dispute between parties is, was this Bonga oil that reached the claimant's property, not...
That is clearly an important dispute.
Yeah.
But there are others, one of which is
The date.
The date, because
Yeah.
obviously the point about the limitation period.
But Shell's case is not, oh, it didn't happen in March, it happened the previous December. Their case is, it never happened, because it was all cleaned up offshore. Alternatively...
Well, I dare say, but
Yeah.
the point is, what you were being asked to plead,
Yes.
what the date of damage pleading directed by Mr. Stuart Smith was, in the Mr. Justice Stuart Smith was required to do, was to say, here are 479 communities, here's the date that we say the oil from Bonga washed up in those communities. And the schedules, therefore, are the key part of this pleading. I'm sure if it goes ahead, no one will mind you having pleaded all the rest of the material, but that wasn't really what you were being asked to plead.
No, I accept that. But the question, the reason I'm stressing this point is it goes to the question of whether they're prejudiced by not having the dates on the 2nd of July and having them instead on the 2nd of October. Because,
Oh, I see. Sorry, I thought you.
Well,
I thought you were just trying to show us the extent of the compliance. That's the heading I've got down.
I am, but that links to the question of prejudice. And my point is, of course, I accept that the dates had to be pleaded, but there is a detailed pleading of why we say Shell are wrong to say A, that no oil reached the shoreline at all, the Atlantic shoreline, and B, why they are wrong to say no oil then migrated inland, because those are the things that they have contested so far. And we obviously, to prove that the oil...
I was taught pleading that was called jumping the style, but...
Let me, I'll show you some of the other material and you'll see why I think that's... Anyway, so that's the pleading. So that was accompanied by...
Are we leaving the pleading? Because if we are, can you turn to
Yes.
page 1080?
Yes. Yes. Yes.
Because as far as Mr. Justice Stuart Smith's order, it's section F that seems to me to be the critical part. I mean, it is, a page and a half, but this is the bit that identifies the date. It obviously refers to the witness statements, but it summarises when the oil first reached these various communities. And on the second page, 1081, there is, praise be, a map.
Yes.
Which shows where these communities are, which you'll recall as a question I asked at the hearing in July. And so this is it completely explicable as a case about when the date of damage occurred. Of course, the point is that it relates to 5 communities and however many of the individuals.
Yep.
But this is, so it seems to me, what Mr. Justice Stuart Smith had in mind.
Well, I certainly agree with that. And
It is perhaps therefore rather unfortunate that so much ink was spilt on things you weren't asked for and didn't arise at that point.
Well, logically, we have to prove that it was Bonga oil, that not simply the date that some oil
No,
arrived.
but sorry, that's proving, that's evidence. I'm talking about pleading.
Oh, pleading, yeah.
Well, it's an important distinction.
Yeah.
Courts from time to time object to how pleadings have become just sort of summaries of evidence, but this is an extreme example of it. Really, what you were asked to plead is Section F.
Well, yes. Well, this was an unusual case, to some extent, in that we were ordered to serve a package with the pleading, the witness statement, and the expert evidence all on the same date. But
Okay. Well, perhaps I'm afraid I haven't been able to resist
no.
going into being a little bit
These
critical
are
of the
very-
extent of the pleading, but all that matters for the moment is the point that you clearly did plead in Section F, what you've been asked to plead, but only for 5 communities.
5 communities and 4 individuals.
Yes.
Yes. And my lord, and maps is another thing that we have been working on in the period over the summer. And my late friend Mr. Cribb is aware of the latest position and will be able to address you on that, because I know it's something Lord Justice Coulson asked about. I think Mr. Cribb may have addressed him about at the previous appeal hearing. But
Well, I have retained from the previous hearing the maps with which I was provided, which very properly you were very quick to say were not very helpful, and they're not. But whereas, of course, this one is, because it identifies at least some of the communities with which we are concerned, and when the...
And I think Mr. Cribb, it may be convenient if Mr. Cribb just addresses you briefly on this aspect now, because the new maps, as I understand it, will enable one to locate the additional communities that we're hoping to serve for the date of damage for, if we're given permission to do so following a successful
When you say the new maps,
well,
no, Mr. Dunning, when you say the new maps, what do you mean? We had established half an hour ago that you wanted to serve reformatted schedules only.
well, yes, but didn't understand that question to be directed to the maps, because we addressed the maps in our letter, I think, on Monday, and said that we
Are you also asking to serve maps?
Yes, I am.
Right.
And my lord, can Mr. Cribb explain where? Because just to set the background, this is an area where there are no official maps. So we are those working for the claimants had to make maps from scratch in order to give information as to where these places are located. That's my understanding of the position. Could you just address the court briefly on that?
My lords, I'm grateful, as my learned friend Mr. Dunning has just said, in addition to the schedule, which is the list of dates added, the claimants have also prepared a new set of maps, because obviously the list of dates needs to be corresponded to a map showing where the claimants and communities who've been given a date are, rather like Section F.
Well, is there a map? I've asked this question before. Is there a map in the pleadings that shows the 479 individual communities?
In the previous state of damage pleading, no. The best
In
map
any
is
pleading?
in any of the existing pleadings, the best maps were the ones I showed you, my Lord Coulson, at the last hearing, which we accepted.
Well, they don't show that.
Were not good. We accept.
They don't show the 479 communities.
And
Because just as a matter of common sense, wasn't that the starting point 3 years ago? A map showing where these communities were. These communities were said to be claimants. So a map showing where they all were and how the individuals related to the communities was a starting point, wasn't it? I've always been baffled by that, I have to say, as to why there wasn't that. And then the date of damage, I can see, could be built on those maps.
my Lord, I'd absolutely accept that it would have been better if there was a map 3 years ago. wasn't. As matters stand, there are 5 communities and 4 claimants, and they are covered in the map in the date of damage pleading in section F that we've just looked at.
Yeah.
If my lords were to allow the appeal and to allow the revised schedule with the dates in, the intended appellants would also seek to add to that a further map which does show where the vast majority of the claimant communities are. There are a small number which are not covered, and as I submitted below, that is because of the difficulty for the terrain, and if the gap becomes a problem, that ultimately is a problem for the claimants. But to accompany the proposed schedules with the dates, the claimants have prepared new maps, which they look like the map in section F of the date of damage pleading. They obviously cover a much larger area. They obviously cover a much larger number of communities. I have examples if the court wants to see them today.
I think we probably don't. It's useful to add an overview. I don't know whether that's enough for my Lord's purposes. Thank you very much, Mr. Cribb.
I'm grateful for my lords.
And my Lord, just on your question about 3 years ago, I've just asked the court to bear in mind that a different firm of solicitors was handling the matter until 2020 July, when that firm ceased trading.
Yeah.
That's Johnson and Stella, and a different counsel team was handling the matter when these proceedings were commenced, and for the first at least 12 months. I think.
I've got August as a sort of change. August of last year as a changeover date.
August of last year, at the end of August last year was when at the end of August when Rosenblatt came on the record, yes, and there was a brief period when there were no solicitors on the record, which included the date when the judgment was handed down. Following the judgment, the 2nd of August, I think, and Mr. Jalla appeared in person at that hearing. So my Lord, so what was served was the date of damage pleading, 5 witness statements, which I can give you the references for. They're in the supplemental bundle. It sounds like the court's read them already at tabs 20 to 23 and tab 47. Mr. Roche's witness statement, which is at tab 28, and also some Civil Evidence Act notices with 5 further witness statements, which are at tabs 29 and 30.
Those don't add, on this point, they don't add anything to the date of damage.
No, they add on the general migration aspect. And then the experts' reports, which were served, were a very comprehensive report by EPE, which stands for Environmental Protection Engineering Essay.
When you say comprehensive, it's not comprehensive, is it? Because it doesn't say anything about individual communities. I mean, we haven't got the full extract, but...
No, it doesn't deal with... but it deals with the 3... It has 3 chapters.
Can we see... We've only got extracts.
We've only got extracts. We could certainly provide the whole... But the topics it deals with...
Well, so where can we look at the...
It's tab 26 in the supplemental bundle.
Just so it's clear, all we've got is the table of contents.
Yep.
Which difficult to get any sort of take any sort of view from, except obviously a lot of topics are covered. And a introduction setting out what their instructions were, and the broad structure of the 3 chapters. It doesn't really.
Yes.
But anyway, what do you? So we're in a position where we haven't seen the report. In fact,
no.
But what are you wanting to tell us about it?
Well, the report covers those 3, the content of those 3 chapters, which is how the spill was able to migrate from offshore to the Nigerian Atlantic shoreline. Firstly. Secondly, the mechanisms by which it could then migrate inland and how it might have taken years to do so. That's the second topic. And thirdly, it addresses the defendant's case that the oil was successfully dispersed at sea by the use of chemical dispersants, and that the oil which did reach the shoreline was a separate mystery spill for which they're not accountable. So those are the three main topics.
Yes.
Of the expert evidence. But I entirely agree that they weren't able to, they're not able to produce, as it were, a soil sample with a fingerprinting from one of the community sites or something.
Yes, I'm not necessarily being critical. I just wanted to be clear when you said it was comprehensive. It's comprehensive at a level of generality.
Well, as to migration inland and why it could have taken years to do so, I think it is comprehensive. But it isn't explained.
It isn't about these particular communities, these particular inlets, this particular geography. It sounds from what you said they didn't even know which inlets or geography this is, because they didn't know what communities they were dealing with. They didn't have any maps.
That may be the case. And then the second expert report is the expert report of the firm Brooks Bell, which is again in the supplemental bundle at tab 8, but extracts only. And this analyses a report that Shell themselves had procured, which was leaked by a whistleblower, and which was a report by a UK firm called Fugro Geo Consulting in February 2012, where they had fingerprinted samples of oil which did hit the coastline. And what Brooks Bell have then done is to examine the Fugro report and conclude that many of the samples of oil taken from the Nigerian Atlantic coastline have a chemical match with Bonga oil. And therefore it contradicts Shell's case that no Bonga oil hit Nigeria, hit the territory of Nigeria. And the other thing is not relevant for present purposes, but we did serve the comprehensive report of the Nigerian lawyer dealing with the applicable Nigerian law limitation period and whether it's 5 years or 6 years, which is another issue to be determined at the date of damage trial. And so that was what was served, and in my respectful submission, if one goes to the July skeleton, which is in the core bundle, volume 1 at tab 10, sorry, I've got a false reference there. I'll come back to that later. So now the respects in which my clients were unable to comply was that they weren't able to plead for a handful of dates, more than a handful of actual dates, and
Plead or provide witness statements in relation to dates, because that was the order.
yes, such witness statements as we needed or intended to rely upon. Yes.
Yes. Because that was the order, because Mr. Justice Stuart Smith envisaged that these people would be saying this is when the oil first either my land or my community's land.
Yes. I think now I shall turn to the specific grounds, unless you have any more questions on the background. Or how,
No,
how
thank
we've
you.
got here. So ground one, we say that the learned judge failed to have full and proper regard to the draconian consequences of her proposed decision, and I certainly made that clear at the hearing, and it was clear also from our skeleton argument. And the references are to the July skeleton argument, which is in the core bundle, volume 1, tab 10, page 147, paragraph 88, and also the July transcript, which is in the supplemental bundle at tab 33, page 296, at page 40 in the transcript. And indeed...
So sorry, I was just marking up the skeleton. Transcript is in the supplemental bundle, did you say?
It is in the supplemental bundle at tab 33, and that's the... again, it's another thing you might want to pull out or read in more detail, because that's the entire transcript of the hearing, save for the judgment, of course.
No.
And the reference for that was page 40 in the transcript, which is on page 296 in the bundle, where starting at line 7, I submitted. So in circumstances where on our side, the claimant's side, they face truly exceptional difficulties, we've set out in our skeleton argument and the evidence of Ms. MacLeod and Mr. Roche, where if they're not permitted to add to the dates, many individuals and communities will not be able to pursue their claims. And on the other side, there is little, if any, prejudice to the defendant from being able to supplement those schedules or specify the dates in the schedules. We say this is a good case for an extension of time. And indeed, I don't believe that Lord Goldsmith did suggest during the course of the hearing that, that there wouldn't be a very dramatic effect on the ability of all bar the 5 communities and 4 individuals to pursue their claims. And he wasn't suggesting that they could still pursue their claims if they hadn't served the date of damage.
But this is a point that cuts both ways for you, isn't it? If it was that obvious, hardly conceivable the judge wasn't aware of it.
Well, that's what I want to take you to, because I'm now going to turn to the judgment and we'll see what the learned judge actually says. So starting at paragraph 13, this is on CB, page 118. And she refers briefly, starting on the previous page, to what had been served, and then in paragraph 13 she says, therefore, as of the 2nd of July, claimants have served, as required by the court, a date of damage pleading, lay witness evidence in support of the case, and expert evidence in support of the case, together with expert evidence on the Nigerian law of limitation. However, the date of damage pleading and the evidence served does not cover all of the claimants as anticipated by the court when the order was made last December. She says the claimants in their application wish to produce a further schedule which will contain the existing schedules of the particulars of claim in both actions, but reformatted so that additional evidence or assertion is included as the alleged date of damage provided. Now, just pausing there, of course, it was an understatement to say it doesn't cover all of the claimants in the first sentence of paragraph 14, because it only covered 4 individuals and 5 communities. And what then happens is, if one then looks at paragraph 15 the learned judge says, claimants have clarified through their leading counsel, Mr. Dunning, that they're not seeking to produce new witness statements. So that's correct. But they wish to produce the reformatted schedule so as to identify the dates on which it's asserted that damage occurred. And then she says, the court has been told that approximately 900 entries will be made to the existing schedules so as to provide the additional case on the date of damage for those individuals and communities. Now, with respect to the learned judge, she appears to have possibly misunderstood that when I gave the reference to 900, I was merely saying how many could comply on that date, as opposed to how many we were seeking permission for, because we were seeking the permission for all of them, and such of them could do it by the time that the court allowed.
No, you'd applied for the 20th of August.
Exactly. But I mean,
and you didn't give a figure as to what you could produce by then. So that was the best you established. That was the best information you had as at the 20th of July.
Yes, absolutely. And I wasn't able to give. It wasn't that I was withholding a figure as to how.
Of course not.
I mean, we didn't know how many more we would be able to do.
Yeah.
What would be helpful, and perhaps you were about to do this, in which case, forgive me, would be just to see the exchange to which she was referring in the transcript.
Yes, I think I can probably identify that. Can I come back to that? I will come to it in a moment, because there's another reference to the 900 on the next page, where the learned judge says at paragraph 19. Having set out my submission, she says that for those reasons Mr. Dunning submits, it would be reasonable for the court to grant the further limited extension of time to the additional limited exercises that have been identified. It is submitted no prejudice will be caused to defendants because they already know the general thrust of the claimant's case. They've already received the detailed expert evidence on which the claimants rely. Also, the defendant's main line of defence is that no damage has been caused by the Bonga oil spill because none of that oil reached the shoreline. As against that, it's submitted that the claimants, by the claimants, that if they're not allowed to plead the date of damage in relation to the additional 900 or so names in the schedule, those claimants will be particularly prejudiced because they will not be able to advance their claims. And so, again, what appears to be the case is that the learned judge appears to think that the application relates for 900 out of 27,000 rather than asking for a general extension for all of the 27,000 to be allowed to give a date of damage. And of course the correct position, as at that point of time, is that only 4 individuals and 5 communities had pleaded the date of damage, and that left 27,800 odd individuals and 474 communities. So we were not seeking an extension of time only for 900. We were seeking extension of time for however many we could do by the date which we proposed, the 20th of August. But at that point in time, on the 20th of July, we could only do it for 900. But she seems to have thought, reading this judgment, that what was going to happen is that 900 wouldn't be able to pursue their claim. And then if we could go on to then we had she sets out Lord Goldsmith's submissions, starting at the bottom of page, paragraph 21. And then if we turn forward to paragraph 37, she says...
without wishing to cut you off,
yeah.
Is the point that between paragraphs 37 and 46, she doesn't refer to the consequences to the claimants if the extension is not allowed.
That's one point. But it is. It is slightly worse than that because there are positive statements to indicate that she didn't appreciate the draconian, or didn't take into account the draconian effect. And so if you look at paragraph 38, she said in paragraph 38, the court considered this is a case where there's a need for an early resolution of some of the key issues in the case. And she says, and then the last sentence of 38, having regard to the need to deal with the cases expeditiously as well as fairly, this is a case that needs to move forward and in which there needs to be a resolution. Well, that is all fine as in one respect, but it fails to take account of the fact that, quite apart from us saying there was no prejudice, which I'll come back to, this is not going to be a resolution for all bar 4 individuals and 5 communities, because they're not going to be
Is that
able
entirely
to...
fair? I mean, the original action, there were 2 claimants. And then their claims, as you indicated on the last occasion, go to the question of the remedial scheme. Now, Mr. Chujaw didn't do a date of damage pleading, but Mr. Jalla did. So, at the moment, by reference to the 2017 action, there is a claim made by Mr. Jalla in relation to a remedial scheme and either an injunction or damages in lieu, arising out of that action. So one of the 2 named claimants.
Yes.
So it's not quite as stark as you put it.
Well, I suppose I am. You're right. I'm focusing now on the 2020 action because that is the main action so far as the class or the group is concerned now, obviously.
But am I right in thinking that the distinction you made last time still applies? On the last occasion, you were very clear that the 2017 action is the only action in relation to the remedial scheme, and that the 2020 action was the claim for what's been called individualised damages.
No, I don't think that is correct. I think what the point I made, or intended to make, was that we were seeking remediation in both, but the second action also had their individual claims.
That's not how it was put to us in July. It may not ultimately matter, but it was not how it was put in July. Because it was that unity of interest.
Yes, of course.
That was the principal point, as you said, gave rise to it being a representative action, because it was the claim for the remedial scheme.
Yeah. But I lost on that.
Well, I follow that, and I also follow that you haven't amended the pleadings, so it may be that having lost on that point is still open to you. But certainly, it was my understanding in July that the 2020 action was for individualised damages only. But you say now that you've lost on the 2017 representative action point, the 2020 action is for everything.
Well, as my lord says, this probably isn't crucial to any decision we have to make today. But if there is a misunderstanding as to something that was said on the last occasion, presumably, I see we have a running transcript for this hearing. There was a transcript for that hearing as well.
Yeah.
It would be easy enough with your team of juniors to spot the exchange on which my lord refers.
But certainly in terms of what is the correct position, and I always have to check what I said last time or the impression I gave last time. But the pleading in the 2020 action does claim clean-up and remediation.
Right.
And it's in the core bundle, tab 15, at paragraph 211.
Well, can I suggest that I'm sure that pleads what you says it pleads. Could you do? We're certainly going to go over the short adjournment. Could someone, at least I assume we are, could someone find the passage that my lord had in mind in the course of the hearing in July, just so that we can bottom this out? May in the end not matter, but
We're certainly...
okay, now we'll just go back to where you were.
So I was on paragraph 38. Then if we go over the page to 39, she says she takes into account that failed to meet the timetable, talks about the pandemic, and she says that those factors already been taken into account by the court, fixing and revising the timetable. That is, no one knew what would happen in 2021 when the timetable was revised, for example. I mean, no one knew the exceptional difficulties that Mr. Roche would face or how the pandemic would play out. I'm saying so it's slightly unfair to say that the factors are already fully taken into account, because one never knows what's going to happen in the future. But I'll move on to paragraph 40. Now, paragraph 40 is with respect to the judge simply unfair and wrong, because she says...
So sorry, I just want to keep...
Yeah.
The ground of appeal which you're addressing now, ground one, is that the judge misunderstood the impact of the refusal of an extension. He thought it would only affect 900 people, whereas in fact it would affect everybody except the 5 communities and the 4 individuals. The passages you're taking us to now don't go to that point, do they?
No, they don't.
Well, I'd rather have these done in a structured way, but...
Okay. What I was trying to do was to show that they didn't go to them, but at the same time show why those passages were wrong as well. But I can see that it's slightly confusing for me to do it like that. My point about paragraph 40 is this, that the learned judge has misunderstood the order that she previously made, which did not give us the ability to identify tests or samples prior to serving the date of damage pleading. And I won't spend time on it, but it's the order which
is this a ground of appeal?
No, it's not a ground of appeal.
Well,
it's just, it says something that's also happens to be wrong but doesn't take into account the draconian effect in any event. And then, now the next paragraph that I want to draw your attention to is paragraph 42, which does, I think, very much support the point that I'm making here. And she says at 42, the court considers the prejudice of the defendants if the claimants are granted further time to perfect their case. Now, that might be read in different ways, I suppose, but it does seem to suggest that she's not grappling with the draconian impact on the entire class of claimants other than 4 individuals and 5 communities, because she's talking about the claimants being given time to perfect their case. Well, that's really a mischaracterization of what was at stake in my respectful submission. Then we have paragraph 43, which deals with Lord Goldsmith's submission and prejudice and court's resources in paragraph 44, and I'll come back to those when I deal with ground 3. And then at 45, she says, drawing all of those threads together, the court considers that the claimants have had sufficient time to identify the witness evidence and produce the expert evidence on which they wish to rely in order to plead and present their case on date of damage. course, I've made clear to her, and she herself noted that I wasn't asking for time to put in any further witness statements. She says, I note the claimants are not seeking permission to serve further factual witness statements. The changes that are proposed to the existing schedules in order to insert dates against perhaps 900 entries would provide a formidable new case that the defendants would have to investigate, into which it would be required to respond. And I suppose there are two things there. One is that she's talking again about the 900, and then she's characterising it as a new case, whereas we respectfully submit it's not a new case. It's a case that has not been pleaded by reference to a date, but the case about the spread of the Bonga oil has already been pleaded in general terms and supported by the expert
Isn't
evidence.
what she's referring to that the whole case that based on migration of oil inland was a new case in the sense that it first emerged, as Mr. Justice Stuart Smith made clear, in the hearing before him. And that is why he said, before I can decide whether this case can be allowed to proceed, because it has limitation problems, I must have it pleaded. What she's saying is, it's a new case in relation to those extra people who, if your extension is granted, whether it happens to be 900 or more, would then have to be examined. Isn't that what she means by a new case?
I would respectfully suggest that's not. I mean, first of all, what you've said is entirely accurate in terms of what the history of the matter. But that's not, in my respectful submission, what she is doing. What she's doing is accepting Lord Goldsmith's characterisation that they would have to investigate all these dates. Because that's what she says, a new case that the defendants would have to investigate.
But that is the case that Mr. Justice Stuart Smith opened the door partly to was inevitably a case that would require any case where you pleaded a date of discovery which was potentially, date of damage for which there was potentially, you were potentially in time, would require a great deal of investigation.
Well, that's what you might think if you weren't familiar with the way that Shell has responded to this proceeding. I'm going to come to the material.
Mr. Dunning, all of the directions in this case, always assumed that the defendants were entitled to a considerable period of time to investigate the date of damage that was the subject of the expert evidence, the statements, and the pleadings. It was originally 5 months. I think it got reduced to 4, but it was originally 5 months. The submission that, well, actually they didn't need any of this at all, on the face of it, seems to fly in the face of the whole structure of the case management directions made by Mr. Justice Stuart Smith and then revised in November 2020.
Well, so the answer that I could put to that is that they had the general case about the spread on the expert, and they had the expert evidence about the spread inland through the water phase and why it would take a considerable period of time for the oil to appear. And all this was then putting particular dates on that spread to supplement the 9 that had already been pleaded. And it was, if you like, more of the same. It was not going to give rise to, realistically, it was not going to give rise to individual investigations of a new case. It was a case that had been pleaded in the date of damage pleading, supported by the EPE report, particularised for 9, for individuals with 5 communities, and we now were seeking to particularise it for a greater number.
No,
that's how I would put it.
You were going to provide a reformatted schedule. You weren't going to provide witness statements. So you weren't going to have Mr. X, Miss Y saying I remember the oil first struck on such and such a date.
That's accurate, but I characterise it differently, Michael.
Well, fine, I get it.
It's factually accurate, but I characterise it as not being a new case, but simply an extension of the existing case. And that is indeed why I didn't pursue further witness statements, because we were contemplating pursuing the case without further witness statements, and now we're contemplating, and that's why I made clear today, we're not seeking to serve any further expert report. Simply want to plead the dates. And
But how could you can't plead a date without evidence in support of it? How can you contemplate proceeding without witness statements?
Well, the evidence that is for the trial, but the evidence in support of it will be the EPE expert evidence.
But that won't prove when it arrived at any particular. All the EP expert evidence does, as you've explained it to us, is show that there are mechanisms by which there can be delayed migration inland. That's fine, and that may help you a lot. I quite understand that. But the other half of the equation has got to be someone from each community saying, and it arrived at our community on a date within the time limit, whatever that's eventually held to be.
Yeah.
And that's an essential part, isn't it? And that's why Mr. Justice Stuart Smith made his order.
Well, my lord, I hear what you say, but I'm just dealing with the reasons that the judge gave, and the reason that my respectful submission, one doesn't see a proper consideration in here of the draconian effect of her order refusing us to lead the dates, and one does see positively statements like 900 and, in particular, perfecting their case, which is an understatement, to put it mildly, when one's contemplating 27,000 odd individuals and 400 communities being unable to pursue their case entirely henceforth.
So the answer to my earlier question is yes, it's the fact that there's nothing there that says the prejudice to the claimants. Plus you point to some of the bits of these paragraphs which you've taken as to, which you say is consistent. It's not just simply an omission. You say that's consistent with the judge not having fully thought through the draconian consequences.
And the 2 points in particular are the 900, which is, you see in paragraphs 15, 19 and 45. That's point 1. And the perfecting their case expression, which is in paragraph 42, combined with the absence of a statement of course I fully take into account the draconian nature of refusing, or something like that. So that's ground 1.
Yes, so just before we leave ground 1, I have now found the passage where the 900 comes from, and it's at page 289 of the supplementary bundle, and it is, well, the exchange starts on the previous page, at page 9, where Mrs. Justice O'Farrell is trying to find out exactly what relief, what you're hoping to do with the extension. Don't think we need look particularly at all of that. That's there.
Yeah, that's correct.
And then on the next page, sorry, the next group of 4 pages, you say at the bottom of page 11, I'm going to give you a number in a moment because I've just been passed a message.
Yes.
Then you digress for a second, and then at line 7 on page 12, you say, the instructions I have at the moment is that currently that must be the solicitors, have had responses from about 900 individuals across 6 communities, which they have been able to put into schedule form. They're still working on it, still working on collating it.
That's
then
correct.
Mrs. Justice O'Farrell makes the point that my lord and I have just been making to you, but those are just dates and not evidence. That's a separate point.
Yes.
And That, as far as I've been able to identify, is where the 900 comes from. Is that right? Is there any other passage where you further clarify what you mean by it?
Yeah, no, that was the passage I myself had marked up, my lord, and if I hadn't, I think...
My Lord, Lord Justice Edis suggests there's more at page 293.
On 293, the 900
Oh, yes,
individuals,
it's
the judge
mentioned
asks a question.
It's mentioned subsequently, but in answer to my Lord or Justice Underhill's questions, that's where it came up.
That's where it starts.
That's where
yes.
it...
May I just draw my learned friend's attention to what he said at page 294, at the bottom of what is page 32 of the transcript, on the top of page 33. I'm sure he'd want to deal with that.
Yes. Well, you better show us the passage. 294, which internal pages?
That's internal page... it's internal page 32,
Yes.
which the paragraph which starts with, of course, there's the question that's been truly great resources, and then the sentence, the consequences for there to be an extension as opposed to no extension are as follows. And then my own friend goes on to say, if there is an extension, the consequence will be minimal, and that's obviously his prejudice point, which will be dealt with. On the other hand, the consequences for the claimants will be, if no extension is granted, that any of those 900 or so communities or individuals who are currently able to put forward and have opened with some more, because their case has not been pleaded, they will be shut out.
Yes, I see.
Yeah.
Well, that's helpful.
But,
Can we just
Yeah.
identify two threads here? The first is that it's clear, you may say it doesn't appear in the judgment, and that's maybe a fair point, but that Mrs. Justice O'Farrell was making the distinction between pleading dates and providing evidence of them.
Yes. Yes, I accept
Because
that.
she asked that at page 29 on page 293.
Yep.
How do you propose to prove your case that they were impacted? Secondly, then there's the question of, did she think those were all the cases? So whether the 900 were all the cases. And actually there are 2 points. There's a third point, which is Lord Goldsmith's point, which is that it's actually clear from the passage he took us to that she must have been alive to the fact that, as you were submitting, they would lose those who weren't able to plead a date and provide evidence in relation to it would lose their claims altogether.
Well, can I take the first point about the 900? So if we go back to the passage you took me to, my lord, first of all, at 289 in the bundle numbering, page 12 of the transcript. Yes, I said 900. Had there been responses, which they've been able to put into schedule form, but they're still working on it and still working on collating it. And so what I obviously meant to convey, or perhaps I wasn't clear enough, was that there would be, we hoped, many more by the 20th of August. So what I wasn't intending to only limit it to 900. And one could see that.
If you didn't get the 20th of August, if she'd said, do it tomorrow.
If she said
would
do
have
it
been
tomorrow,
900.
we would have then said,
Yeah. So
if she'd gone for the lesser option, said, well, I don't think there'd be that much prejudice if you do it tomorrow or the day after, but I'll allow you to serve the 900 you already have ready, then we would have obviously gone for that.
Well, you would have gone for that, but you weren't able to provide witness statements for those 900.
No.
Well, wouldn't that have been fatal?
Well, that we had some debate about that, which you've seen, and that doesn't feature in her judgment, in her reasons. So I'm not attacking anything in her reasons on that. We submit it wouldn't be necessarily fatal because it would depend what inferences can be drawn from the evidence that had been served on the 2nd of August, 2nd of July, namely the expert evidence and the factual evidence that had been served. So if, for example, I'm just to get off the top of my head, let's assume one of the communities is further inland from, and they have supporting evidence, in terms of a witness statement. And then there is a pleading of a damage, let's say a month earlier, 2 miles closer to the shore. Then it might be possible, together with the expert evidence, to draw an inference that that did indeed occur there on the date that was pleaded.
Speaking for myself, I can see how you might mount a case based on a factual evidence from people who live on the banks of the estuary, which will show the progress up the estuary of an oil slick.
Yeah.
And you don't need to call all 28,000 people to prove that. You might be able to prove that with the experts and just a few riverine occupants. But in order to make an individual's case, you've still got to prove that that individual owns property in that place and therefore was affected by the oil slick. So how do they mount a case without a witness statement?
I would have to check whether the date of damage trial was intended to encompass the question of the nature of a person's interest in the property, because I'm not.
Well, they may well.
Sure
So this is
was.
about whether they have a viable claim, and
Yeah.
in order to prove that they have a viable claim, they have to show that they have property which was affected, and prove the date when that happened. Isn't that right?
Yeah,
I wonder whether this seemed to me to be how Mr. Justice Stuart Smith understood it. He made the point in terms at the hearing on the 23rd of March, it was March, that you wouldn't need witness statements from all 28,000. And what I understood him to be saying is effectively you would need one witness per community, because if you know the oil washes up at such and such a village on such and such a day, in the real world, everyone who can prove that they were part of that community will have at least an arguable individual claim. My Lord's point may still be right, that they may not actually have suffered any damage because they had no land, they had no property, or it was, up a hill somewhere and wasn't affected. But in terms of what was intended by the order, broadly speaking, what was intended by the order was there would be a witness statement for each community, which would be good enough for, at this stage of the argument, for everyone in that community. Now, have I understood that correctly?
well, maybe we should look at the order itself, my lord, because
We can, but I don't think that tells us very much. It's more the things that he said in the course of his judgment. But let's do whatever you want. His order, if you want it,
is in
is behind tab 13 in the supplementary bundle, and it's on page 78, 14.1b.
yeah. So, just reading that, obviously it says A is to be a date of damage pleading setting out the claimant's case on when the relevant accruals of damage occurred. With sufficient particularity enable the defendants to know the case they have to meet. Any lay evidence on which they rely, and any expert evidence upon which they rely. Now we say, just looking at that, we have pleaded the general case in the date of damage pleading. What we haven't particularised, other than for 9, as things currently stand, is the actual date when it occurred. We have served lay evidence. We're not seeking permission, and I don't have instructions to seek permission for any further lay evidence, nor did I seek it before Mrs. Justice O'Farrell. some lay evidence has been served, and some documents and some Civil Evidence Act notices and statements under 5 statements under Civil Evidence Act notices. So far as expert evidence is concerned, we served 2 reports, the Brooks Bell and EPE reports.
We were only going to this order in order to make good in order to identify what it was that Mr. Justice Stuart Smith was expecting to be delivered, and we can see that from his judgment, which is in the judgments bundle behind tab 2 at para 14, page 113, where he says it's for the claimants to decide what evidence they serve, right? Because it appears that groups of claimants live in the same communities, so they may have dates of damage in common. It's not a requirement of this order that evidence from each and every claimant must be submitted. So all I was raising was that it's pretty clear what Mr. Justice Stuart Smith thought was necessary in order to be ready for the hearing, the date of damage hearing, was a witness statement verifying the pleaded date of damage for each community. Yeah. That's right, isn't it?
Well, that would appear to be a fair reading of his judgment.
Yes.
But there wasn't. We're not in breach for having failed to serve that, and nor was I asking.
Nobody. You're not being struck out either.
No.
So you're not being struck out for breach, but you're being put in a position where, when the hearing comes up, you will not be able to prove your case because it's not a pleaded case. And even if you're allowed to plead it, on what you've told us today, with great considerable emphasis, even if you plead these dates, you won't be able to prove them because you won't have verificatory lay evidence saying the oil washed up in this community on the pleaded date.
Well, that's where I think there is a narrow difference between us, my lord, because I submit that for the trial, whether we will be able to prove them. Because if we can plead them, that it will be for the trial judge to decide whether it can be inferred that...
You mean the trial judge on the limitation issue?
On the limitation issues, to decide whether it can be inferred that those pleaded dates are correct in view of the overall expert evidence of EPE, the limited number of factual witness statements that we do have about specific places, and the maps. And I accept that it's not, that's not a huge amount of evidence, but it will be for the trial judge to decide whether or not that is sufficient to prove the pleaded case. And all I'm asking for is not to put in any further factual evidence or expert evidence, but simply to be able to particularize the dates. And that's essentially...
Well, we see exactly where you are. Thank you. Right, now, you'd finished ground 1. It was us who asked these further questions. Ground 2.
Well, I think ground 2 I can take quite quickly because we've traversed quite a lot of the material. And in fact, our exchange a few minutes ago almost covered the point, which is, Justice Coulson, that if the judge had said, well, I'm not going to give you the 20th of August, but what about the 900, and you've said you can do that almost immediately, what would you have said? And I would have said yes. And it's very hard to see how that...
Out of curiosity, would you have said yes? I thought you were saying you had instructions problems.
Well, I would not have... Let's put it another way. I wouldn't have objected to that course of action if the judge felt that that was one that the court thought appropriate.
Could you just help me with this,
yes.
Mr. Dunning? We looked at page 289 in the supplemental bundle, the transcript,
yes.
behind tab 33.
Yeah.
And the judge on page 288 was asking you what you were applying for. And you said, bottom of page 288, page 10, line 17, 18, my instructions are set out in paragraphs 70 and 75. So you're saying the only application I've got, is this right, is the one I've got instructions to make, which is to get an extension for everybody. So you're not saying, in the alternative, I would like to advance an application in relation to the 900 I can do. You're saying I've only got limited instructions to advance the one that's been set out on paper.
I was making it very clear that those were my instructions, yes. And but that, in my respectful submission, that doesn't preclude the court on its when faced with a case management decision of considering whether there is a less draconian course which can be taken. And that there's quite a lot of authority, but we cited one. The court, when not allowing 27,000 claimants to proceed by not granting an extension of time, could say, but nevertheless, I've been told, although they haven't applied for it, that 900 are in a position to proceed. I don't think there'll be any additional prejudice to serving that in the next couple of days, because if boys already agreed that they would accept the evidence, which they might have anticipated would be far greater, on the 2nd of July, if they get it on the 23rd of July, I think they should be able to deal with those 900 and making an alternative order on that basis. And so that's really the second ground. Now, ground 3 is my submission that I addressed the court on absence of real prejudice, or material prejudice, and absence of any real jeopardy to the trial date. And I can explain why we say that is the case, and why we say that the defendants are protesting too much, and that the learned judge hardly made any reference to those arguments, and didn't address them and give reasons for dismissing them. So the points were as follows. First of all, the date of damage pleading and the expert evidence have been served.
I'm so sorry, Mr. Dunning. What would help me very much in a case of the judge didn't deal with it? Argument, which one gets from time to time. We can see your skeleton. You may be referring to us to that in due course. But it would also be helpful to see just where you made those submissions in the oral transcript.
I'm going to give you the reference.
You are going to? Okay, that's fine. Thank you. Sorry, I'll keep quiet then.
And but I want to just tell you what the points were now.
Yes, of course. Okay.
So,
yep.
Obviously, I made the point that we'd served the date of damage pleading and the expert reports, and I showed her extracts of the date of damage pleading, and I gave her the references to the experts' reports, and I think she said she had looked at them quickly. Then I made the point that when they agreed the consent order in June, the respondents were obviously content that they could deal with matters if everything was served on the 2nd of July. So we were looking at, will they be caused prejudice by an extension from the 2nd of July to the 20th of August? And in circumstances where they had agreed to the 2nd of July. Thirdly, I made points about the circumstances of the defendants, some of which I've already made, namely that they'd been aware of the spill from an early stage, they had mobilised the clean-up, they claimed it was successful, they had the Fugro report, they did environmental monitoring, there are many other proceedings in Nigeria, and they have very substantial resources, and they had in fact served a lot of evidence in this case dealing with which I'm going to come to in a moment. And I submitted that, taking into account all those circumstances, this was not really a case where the defendants would be prejudiced in a material way by the limited extension that we sought to plead the dates of damage, and certainly not a case where there was a real prospect of the date of damage trial itself being adjourned. And I made a very considerable point about the structure of the dispute and what evidence had already been served. And I made the point that first and foremost, it is the defendant's case that no oil from the Bonga spill ever reached the Atlantic shoreline at all.
That's always been their case.
That's always been their case.
That was their case when Mr. Justice Stuart Smith made his directions.
Yeah. And
so just so you understand that was therefore known to Mr. Justice Stuart Smith when he allowed them 5 months to respond to your dated damage pleadings.
But my point now is was the limited extension we sought, having served the factual evidence and the expert evidence, the limited extension we sought for the schedules of dates, was that going to cause them prejudice in view of the way that they were intending to conduct their case?
Well, if you start at the end and work back, maybe that may save time. You wanted an extension of time of 7 weeks. If you add that 7 weeks on to the date by which the defendants had to respond, you would get a date at the end of January, which would inevitably have meant that the trial could not go ahead in February.
Yeah, I was suggesting that they didn't need an extension.
Well,
that's my point.
So that therefore must be the point, because you would accept that if they did need the period that they had been given before, if that was simply shunted forward, then the trial would have been adjourned.
Yeah, I was. Look, put it in very colloquial terms. The point I was making, this is the equivalent of a Premier League footballer rolling around on the ground in feigned agony when somebody brushes past him. That this was a gross exaggeration of any prejudice that the defendants would suffer in all of the circumstances. And I took the learned judge to the substantial body of evidence that had been served. And if I can just take you to the transcript, I won't trouble you with all of the evidence, although I can give you the references to it. In tab 33, at page 294, starting on page 33 in the transcript, line 21, it said this is the line which they then pursued throughout all of the following couple of years. And as far as we know, that is still their line, that it was not Bonga oil at all, it was a mystery spill from someone else. And then I said we had a witness statement, and I listed out all of the witness statements, and we have them in the bundles here, that they had served, making this point that there was no Bonga oil anywhere in the territory of Nigeria, and they have completely committed themselves through the evidence of Mr. Samoy, two witness statements, I believe, Mr. McQuitty, and then over the page, another witness statement of Mr. Ola Fimian. And those, we have those in the bundles here, tabs 3, 4, 5, 6, and 7, and 9. And that's why we said that our expert evidence already traverses all the key elements of their case. Because their case was Bonga oil dispersed at sea, Bonga oil never reached the Atlantic shoreline, there was a separate mystery spill, and their Fugro report exonerated them. And we traversed all of the key elements of their case. I also pointed out, contrary to what is in my learned friend's skeleton argument for this hearing, that they had an alternative case, and their alternative case was that even if oil from the Bonga spill did reach the Nigerian Atlantic shoreline, which they strongly denied with all of that evidence that they had put in, then spills are rife throughout the Niger Delta, and there is no way of showing whose oil it was. And again, I specifically addressed this point before Mrs. Justice O'Farrell, And I pointed out to the learned judge in the transcript at tab 33, page 295, transcript page 36, it must be on page 295. That in addition, they had served evidence. Let's just see where to pick this up. It's on transcript page 36 at line 19. Oh yes, and indeed this was the report, Lord Justice, the witness statement Lord Justice Coulson might recall, that was actually read to the Court of Appeal in July. So this is at the bottom of page 36 in the transcript. And I said they referred quite recently in the Court of Appeal to a witness statement that Shell made on the 20th of May 2020 by a lady called Miss Atimi, who made a first witness statement on the 20th of May, we now have in the core bundle, and in particular paragraphs 9 to 27 and paragraphs 36 to 34, where she describes the security and pollution issues affecting the Niger Delta region and suggests that oil spills from sources other than from Shell are common in the Delta Edis state. She sets out a number of reported spills in the Delta and Edis states in 2014 and 2015, which is where many of the claimants first say they suffered damage. The whole point of this, and the reason why Lord Goldsmith read it out again in the Court of Appeal recently, is to suggest that if the claimants are not lying and simply inventing being affected by oil, it was not the Bongal oil, which had all been cleared up and never reached the coastline, and it was oil from one of these other sources that's got nothing to do with Shell. That's exactly the point that they make. And the judge said, are these not issues of causation? We then had a further exchange, and I said at page 38 in the third line, therefore it never hit the land, and that is why I say that the date is really a sideshow. It doesn't matter very much what dates we list, because it's not going to affect how he responds to the application. So that was my argument, which the learned judge didn't grapple with.
That the dates are a sideshow.
They are a sideshow to how the defendant is going to conduct its response.
They're not a sideshow for the trial of limitation issues.
No, not at all.
They're front and centre in that.
Yes, of course. But sorry, I see how that could be misunderstood. But what I was trying to say is this is all in support of a submission that there was no real prejudice. This was feigned.
But the prejudice goes to the limitation trial.
Yes, of course. Yeah.
Where you agree the dates are front and centre.
The dates have to be pleaded, I agree, but they're not going to... The question I was addressing, and I'm now addressing, is whether they get the dates on the 20th of August or even on the 1st of October, that will make any difference to how they respond and conduct their package, their defence, their response that they've got to serve ahead of the trial. And in my respectful submission, one should treat their allegations of prejudice with a very large pinch of salt, and that is exactly what I was submitting to the learned judge. And you see, in all of these points, they also have a point, by the way, that the allegations of all the allegations related to damage by oil are invented. And again, I took the judge to that. Now,
Never said that.
and well, we'll see. What is fundamental to appreciate on all of their arguments is this: that they're not going to be contending for an alternative set of dates, because this is a case where they say it never happened. It didn't happen on date A or date B or date C. Their case is it just never happened because no oil got into the onto the shoreline. No oil got into the Delta region waterways. And in any event, if you suffered some damage from oil, which we don't accept, you can't prove it was bonga oil because there are so many other leaks and sources of oil in that region. And that's why we say that they have our case. We want to particularize further dates, but it isn't going to make a difference to them in real practical terms what those dates are. And it won't cause them appreciable prejudice, and it won't cause there to be jeopardy to the trial date. And my lords, I did make this point. I mean, there are many, I think, references to the transcript I could give you, but certainly pages 15, 31 to 32, 39 to 40, 66. That was also in our skeleton argument for the hearing. And I think also 26.
Well, if it will help you, I've just been, while listening to you, skimming through. It's quite clear this was an important part of your argument as developed already. So.
And I think in reply as well at 121 to 123. And so we respectfully submit, and I'll take you to the judgment in a moment, that the learned judge failed to have regard to what I described as really the structure of the issues in the case, whether it was realistic to think that getting these dates on the 20th of August for a response that was required in the autumn to make any real difference and any possibility that the trial date would be prejudiced. And I made detailed arguments on these points, and the learned judge didn't really deal with them. And if we go to the judgment, we'll see where she makes some reference to part of one of the points. So if we go to paragraph Lord Goldsmith's argument she sets out at paragraphs 21 to 24. So Lord Goldsmith said, granting the extension now would inevitably mean that the date of damage hearing currently fixed for the 21st of February would have to be vacated. That's what she recorded him as saying. And then at 22, Lord Goldsmith submits the claimants have no good reason for a further extension. And then at 24, Lord Goldsmith particularly relies upon the prejudice that would be suffered by the defendants in opposing the claimant's application, and so on. Now, where, if at all, did the learned judge deal with my arguments in relation to that? So in paragraph 19, there is a partial but incomplete reference to the submissions that I made in relation to absence of prejudice. In the second sentence of paragraph 19, it's submitted that no prejudice will be caused to the defendants because they already know the general thrust of the claimant's case, already received the detailed expert evidence, and the main line of defence is that no damage has been caused. So she made some passing reference to that, being my argument, but nowhere does one find any explanation of what she... Firstly, it's not a full summary of my arguments, but in any event, nowhere is there any real description of what, or analysis as to why those arguments were wrong, or any reasoning explaining why Lord Goldsmith's assertions that there were prejudice should be accepted. And then if you look at paragraphs 42 to 43, without analysing my submissions about the absence of prejudice and the absence of jeopardy to the trial date, she concludes at paragraph 42, the defendants will suffer prejudice by way of disruption to their preparation. She says, accept Lord Goldsmith's submission in 43, entitled to know the precision, the case they have to meet, regardless of their primary defence. And then she talks about the regard to the use of the court's resources, which is obviously contemplating that there would be an adjournment.
43, isn't the second sentence important? Regardless of their primary defence, that means even though Shell's primary defence is the one that you've been identifying to us, they are entitled to have an opportunity to consider the detail of the claimant's case and the evidence put forward in support, so they consider whether or not to challenge that evidence. So she's saying it doesn't, whatever they may have said so far, you're advancing a new case here, which depends on the date at which the damage reached the oil reached the particular communities, and they're entitled to consider it and decide what to do about it. And although she doesn't spell this out, initially Mr. Justice Stuart Smith thought they should be able to have over 5 months to do that.
Yes, but I don't dispute that
I
they're
think
entitled to know
addressed-
the case. I'm not suggesting I don't need to plead it now. But my point is that they won't be prejudiced if they only have.
Well, they will
8
be,
weeks
because they
to do it.
entitled to have an opportunity to consider the detail of the case.
But that has to be, well, and again, I accept that they have to have an opportunity, but realistically, they are not going to be pleading alternative dates.
It was a part of your application that you were entitled to the 7-week extension, but they weren't entitled to any extension. So that follows from the submission you've just made, that it was a concomitant part of your application that their time for response would be reduced.
Because, and the reason being, that realistically, looking at how the issues that have been joined and the evidence that have been served, which I've referred to and is in the bundles, their case was not going to be one where they disputed the actual dates. Their case was going to be
With great respect, Mr. Dunning, we don't know.
Well,
because we haven't yet got to the date where they have to respond. But we don't know whether they're going to have a positive case.
well,
I mean,
I
I understand your submission that it's unlikely, but we just don't know.
well, if one is going to decide that somebody has been prejudiced by something, one has to form some view as to the likelihood and whether it's realistic. I'm not saying that, I wasn't arguing that Lord Goldsmith didn't have an argument about prejudice. My point was that he hadn't shown and couldn't show that there would be a appreciable risk of prejudice, because, for the reasons I've given. And I'm asking the court to take a very sensible, pragmatic view. Clearly, he could argue there was prejudice, but I was saying it was fanciful in the circumstances.
I appreciate the judge placed weight on the prejudice issue. How central was it necessarily to the assessment that she had to make? There's an element also, simply, isn't there, of whether you had good excuse for a repeated failure to meet the court's deadlines.
Yeah.
And in fact, in one respect, to say you simply weren't going to comply with them at all, namely the witness statements.
Well, my lord, I don't accept that we were bound to serve witness statements. I know the judge had indicated that that's how we could comply with the order, but we weren't ordered to serve witness statements. And we were ordered to, if we served them, we were ordered to serve them by a certain date. But we weren't ordered to serve.
No, I see that.
Yeah. Now, my lord, yes, of course, but we come back to taking, as it were, an overall view. Has the learned judge taken it properly into account what in my respectful submission, should be a factor of extreme weight to be weighed in the balance, namely the draconian effect of not granting extension of time. That's the first point. Second point, in her analysis, has she grappled with my arguments that although Lord Goldsmith was saying there would be prejudice and that the trial date would certainly have to go, that was unrealistic when one looks at the body of evidence that had been served in the case and the very slim possibility that would make any difference at all to the defendants whether the date that was pleaded was the 10th of March or the 15th of March or the 1st of April, whatever. The actual dates would make very little difference to them because they weren't.
Suppose we were with you on this and we felt that there had been a failure to deal with a particular point,
Yeah.
therefore to give reasons for not dealing with it. We'd have to reach our own view.
Yes. My Lord, that's why we wrote the letter earlier in the week about the relief that we would be seeking if the appeal was to be successful, because then we would ask the court to make its own decision. Obviously, there is a CBC coming up.
Well, hang on. Not sure in the end this is fundamental, but I just want to get my mind straight on this. Suppose we find in this or some other respect the judge misdirected herself.
Yeah.
Fail to take into account a relevant factor or whatever. And we had to, as you accept, re-exercise the discretion ourselves. Are you saying that we should do so on the basis of evidence that is, well, not evidence exactly, but material developments since the hearing in front of the judge, or should we put ourselves back in the situation that the judge was in whenever it was 2 months ago?
Well,
What's the correct
I would say my primary case is that you should do it on the situation that is now. But alternatively, if that is wrong, you should do it on the basis of the situation that the judge was in. And my Lord, this is why it is relevant that when we launched this application for permission to appeal, we did indicate that our intention was to go on serving schedules up to the 20th of August and beyond, so that they would have them. And that's why but we didn't take that course, as you've seen, and Deverboys were vehemently opposed to it in the letter that's in.
We've seen the correspondence.
Yeah, you've seen that correspondence. So where we are now is that if you exercise the discretion in light of the circumstances that exist before the court today, that we would ask you to allow in the schedules with the numbers that I gave right at the very beginning, and I can repeat those if necessary. We are no longer asking to serve any expert evidence.
You said all that, yeah.
And we weren't asking for factual evidence. So it would simply be those numbers and any necessary small amendments to the overall pleading just to capture those numbers. Alternatively, if you are exercising discretion on the basis of the facts that existed before the learned judge, then clearly an option that would be available for the court in view of my submissions on ground number 2 would be to allow the pleadings that were of the 900 that were ready at the time when the judge made her decision, and possibly any others. If
how would we know which those were?
Well, I'm sure we could. I'm sure the solicitors. Well, I'm sure. I would hope the solicitors would be able to identify those, but they may not be able to. I suppose I'd have to take instructions on that because they may have done this on a rolling basis. So, my Lord, in terms of does your Lordship want to be addressed on any aspect of the legal principle? Because I'm not sure that this case involves any novel legal principles. But
I just wonder. I've got one question.
Yeah.
And it's only relevant if the court is considering re-exercising the discretion. speaking for myself, was slightly surprised that Denton and White, the approaching Denton and White, got a reference in the judgment, but not more than that, and isn't a point that either of you, I think, make in your skeletons. Now, in one sense, this wasn't a relief from sanctions case because the application was made at the very last minute on the 2nd of July. But in most cases, by reference to common sense, it was, because the claimants were throwing themselves on the mercy of the court. The claimants were saying, you've got to extend time, otherwise 28,000 claims will bite the dust. As you may know, on the civil courses where they teach new judges, they teach Denton and White, I think rightly, as the best approach, the best course to follow, whether it's a relief from sanctions case or not, where you're talking about delays and possible sanctions. It seems to me that Denton and White is quite a good starting point if the court decided that it needed to re-exercise the discretion in this case.
Well, I would, first of all, I won on this point. I mean, there were 2 points in which the court hasn't been troubled with. But one was that there'd already been an agreement which precluded it.
Yeah, and she said that.
And she was with me on that. And the other was that this was a relief from sanctions situation, and she was with me on that as well.
Yeah.
And in my respect,
Let's say strictly, Mr. Dunning, we don't need to revisit. Let's assume that strictly you're right, because the application was made at the last minute, but within time. My question was, by analogy, is it not a very useful way of approaching the situation in this case?
no, because we're not asking for relief from sanctions.
You are. If we're against you, 28,000 claims bite the dust.
But that's not a sanction. That's a consequence.
Yes,
Okay.
the point is that's the substantive point is the same.
Well,
You are asking for an extension without which most of the claimants will not be able to proceed. Because without an extension they can't make their case. In substance, you are in a very similar position to someone who has actually suffered a sanction because they missed a deadline and something came down.
well, I think in principle they are different situations, because one is where a sanction is where there's been a breach of an order, and therefore a sanction has been attached to that breach.
Yes?
And our situation is that there hasn't been a breach of an order, there's been a failure to do something in the time prescribed by the order and a request for further time in which to do it. And I think I don't know about the judicial training courses, but in my respectful submission, although in one sense they are similar situations, they are different in principle, because
Which is why I said by analogy,
yeah, but
simply as an approach.
yeah, well,
What's wrong with the approach? Looking at the delays, seeing the extent to which they're justified, are they serious?
yeah.
Taking into account all the circumstances of the case. Can I ask you why you don't like that?
Well, it may be there isn't much between us. I suppose I'm balking at the concept that this should be treated as a breach of sanctions case. I'm not suggesting that all these factors are factors that are available to the judge to take into account in the exercise of discretion.
That's really that's my point.
And of course, I think the difference may be the weight that you give to the factors if you treat it as a relief from sanctions case as opposed to an extension of time case. And that's why, and with some sort of presumption that certain factors should carry greater weight than they would do if it was merely an extension of time. But I'm not suggesting that the learned judge couldn't take into account all the background circumstances. But then it's a question of what is the proper way to give those circumstances in the situation that the court is faced with. And all I was going to say, without taking you to the authorities, in terms of case management orders and the correct approach.
We are very familiar with those.
Yeah, I was going to say that the Zuckerman textbook is in the bundle, and the passages dealing with case management orders may be of some help. And in terms of,
if you were to finish your submissions, then you would be finishing them on the dot of 1 o'clock, which would be a great tribute to your professionalism.
Well, but there is a specific section in that extract in dealing with the exercise of appellate jurisdiction in appeals against case management decisions, and that's the one that I would respectfully submit contains the applicable law. The only other points that I probably don't need to take you to, but would refer to if necessary, are the passages from English and Emery, Lord Phillips, and
those
Flannery
are
and Halifax.
mother's milk to us.
Both in the bundles at tabs 6 and 7, if you wish to look at those, but I'm sure you're very familiar with them. And so, unless those behind me have any points, perhaps I'll take the benefit of just seeing if there's anything obvious I've overlooked over the shorter journal.
We'll put it the other way around. I think you would close your submissions. Whereas if you can't think of them now, they're unlikely to be valuable. If something important does occur to you, we may grant you the indulgence of mentioning them. But subject to that, that is your case, as I understand it. Very well, we'll sit again at 2 o'clock.
All rise.